from supplemental is for hearing on the order 41/11 item 27, second appeal 109 of 925.
Please, Your Worship. This appeal has been filed. Finding the judgment.
Conference? Conference? Conference?
Yes, ma'am.
You are the landlord or the tenant?
I'm the tenant.
What is your point?
The whole scenario begins in 1971, Your Worship, when the Shanti Devi has executed a sale agreement in favor of the defendant for a total consideration of rupees 51,000, out of which she took 31,000 and handed over the land to the defendant. Thereafter, this defendant has been coming in possession over the said land, and the defendant claimed the title. The sale deed has been executed in
Agreement of sale, right?
As
Any
exhibit
suit for
A.
specific performance by
No.
suit has become barred by limitation. How can the title pass on the basis of an agreement of sale? Till when did you pay the rent?
October 1990.
October 19. In spite of agreement of sale of the year 1971, you continue to pay rent.
Let us check what in the argument has been come. May I submit? That Shanti Devi Bajaj has also executed a will in favor of Hetram Bajaj, and she
What is
cancelled.
the date of it? Hetram Bajaj. Who is Hetram Bajaj? Who is Hetram Bajaj? आदमी पड़ोसी के नाम से बिल नहीं करता ना? Who is Hetram Bajaj? And what is the date of bill? Bill has been probated.
Executed on 16/1/1987.
16/1/87.
Exhibit F.
Has it been probated? A bill which has not been probated is a scrap of paper. You can throw it into the dustbin. You cannot draw anything from this. So we don't have a case. They are relying upon an agreement of sale of the year 1971, and you continue to pay rent till October 1999. And you did not file suit for specific performance of company. You are a rank defaulter. Second appeal number 109 of 2025. This appeal has been filed against the judgment dated 19/4/2025 within bracket 19/4/2025 passed by the District Judge Rohan Kotta entitled eviction within bracket appeal bracket close number 1 of 2005. Reversing the judgment. Affirming the judgment dated 19/5/2005 within bracket decree dated 3/6/2005 passed in title eviction suit number 5 of 2001 by learned subject 1 Gurda. आप लोग कुछ भी लिखते हैं cause इसमें ऑफिस के point of view आता है. The suit was decreed on the ground of default in payment of rent and the defendant was also directed to pay the arrears of rent to the extent of rupees 1,400 to the plaintiff. The appeal against the same has been dismissed. Consequently, the defendant is the appellant before this court. The learned counsel for the appellant has submitted that there was no landlord-tenant relationship between the parties in as much as the defendant came in possession of the property by virtue of an agreement of sale dated 7/11/1971 executed by entered into between Shanti Bajaj, the landlord,
Shanti Devi Bajaj.
Shanti Bajaj, Shanti Devi Bajaj, the landlord and the defendant for a consideration of rupees 51,000, out of which rupees 31,000 was paid at the time of agreement, and rest amount was to be paid after execution of the registered sale. He submits that the defendant was residing in the suit property as the owner of the property. He has also submitted that the registered lease deed dated 28/1999 within bracket exhibit 7 was fraudulently prepared. Correct? He submits that this aspect of the matter has not been properly considered by both the courts, and accordingly a substantial question of law be framed and this appeal be admitted. After hearing the learned counsel for the appellant, this court finds that the suit was filed seeking eviction on the ground of default in payment of rent under the provisions of Bihar Building within bracket lease, rent, eviction and control Directive Act 1982. And it was the case of the plaintiff that the suit property belonged to Surajmal Bajaj, who had 4 sons, out of whom Loknath Bajaj was the youngest son, and he died leaving behind his widow Mosama Shanti Devi. And in family partition in the year 1966, the suit property was allocated to Shanti Devi Bajaj. She had adopted plaintiff number 2 Siddharth Kumar Bajaj as a son through registered deed of adoption number 48 of 99 dated 28/7/1990. Shanti Devi Bajaj had inducted the dependent in the suit premises as month-to-month tenant at the rate of ₹30, which was gradually enhanced to ₹500, and the dependent paid the rent of ₹500 for the month of September 99, and thereafter stopped making payment of rent in spite of several demands. Thereafter, a legal notice dated 18/1/2000 was issued seeking vacation of the suit premises and termination of tenancy, which was responded by the dependent, stating that the denying the allegations. However, the dependent had also stated that initially the rent was ₹30 per month, and thereafter it was enhanced to ₹60, and lastly enhanced at the rate of ₹100, and the rent was already paid up to January 2000. Ultimately, the plaintiff, ultimately, the suit was filed. The defendant contested the suit by stating that Shanti Devi Bajaj never adopted plaintiff number 2 as son, and she had executed another registered deed by which he cancelled the deed of adoption, and had also filed title suit number 24 of 1999 seeking cancellation of the registered deed. It was stated that no legal notice was ever served against the defendant by Shanti Devi Bajaj, whereas Shanti Devi Bajaj executed an agreement for sale dated 7/11/1971 in favor of defendant number 1 for a total consideration amount of ₹51,000, out of which 31,000 was paid to Shanti Devi, and she handed over the property to the defendant. And the defendant claimed title over the property by the principle of adverse possession. The defendant framed the trial court framed as many as 8 issues, and ultimately found that there was a landlord-tenant relationship between the plaintiff and the defendant was a defaulter in payment of rent. And these issues were decided in favor of the plaintiff, and a decree was passed for eviction of the defendant. The first appellate court also considered the materials on record and held in paragraph 17 that so far in paragraph 17 that so far as registered deed of adoption dated 28/7/1999 in bracket exhibit 3 by which the plaintiff number 2 has been adopted as son by Shanti Devi Bajaj is concerned, the defendant had no right to challenge the state adoption. And otherwise also the deed of adoption has not yet been annulled by any competent court of law. And therefore it could not be said that the plaintiff number 2 was not the adopted son of Shanti Devi Bajaj and he could not have inherited the property left by her. The court ultimately held that it was clear that there was a relationship of landlord and tenant between the plaintiff number 2 and the defendant. And by the time so with regard to default in payment of rent, it was recorded that the plaintiffs claimed that the defendant defaulted in payment of rent since October 1999 and the defendant had not claimed that he had already paid the rent regularly according to the provisions of BBC Act. Rather, the defendant was claiming himself as the owner of the suit property on the basis of agreement of sale dated 7/11/1971. The court recorded that the defendant has not filed any suit for specific performance of contract with respect to the agreement of sale dated 7/11/1971. It was also recorded that the defendant was a tenant as he had to pay rent agreed according to the lease agreement dated 28/1999, but he defaulted in payment of rent since October 1999 and ultimately held that the defendant was liable to be evicted from the suit premises on the ground of default in payment of rent. This court finds that both the courts have given concurrent findings, not only with regard to relationship of landlord and tenant between the parties, but also with respect to default in payment of rent by considering the materials on record. No perversity as such has been pointed out by the learned counsel for the appellant in the matter of appreciation of evidence by the learned court. There being no substantial question of law involved in this case, this appeal is hereby dismissed.
Politician, one idea is planning.
Are you both?
Idea for stay of proceeding.
IA number suggested is dismissed.
कैविएट फाइल किए थे, मेरा कोई रोल नहीं था लिमिटेड फाइल। कल कैविएट नंबर है 251 बता देते हैं।
अपना नाम दे दीजिए, केविएटर
नंबर में
केविएटर
जी
और केविएट नंबर ना
जी।
From bail list for hearing on order 41/11 item 16, second appeal 560 of 2017.
2017 से आपको अभी मेंशन करने का नहीं मन कर रहा।
नहीं, हमको मेंशन करने का नहीं है, फिर इसमें कुछ डॉक्यूमेंट हम मंगाए थे और लोग आया भी था, इसको ला के अगला मंगलवार को हम कर देंगे।
वो तो बात ठीक है, लेकिन
तो
2017 से अभी आपका सब्सटेंशियल क्वेश्चन ऑफ लॉ नहीं बना
अब नहीं बना है
और अभी आपको कुछ डॉक्यूमेंट इसमें चाहिए। क्या डॉक्यूमेंट आपको चाहिए?
इसमें
एडिशनल एविडेंस फाइल करने का मन कर रहा है।
एडिशनल एविडेंस का तो अभी नीचे भी फाइल किए थे एडिशनल एविडेंस का ऑन द लास्ट डे दैट हैज नॉट बीन कंसीडर्ड दैट आई हैव टेकन वन ग्राउंड, उस पर हम नहीं जा रहे हैं। एडिशनल एविडेंस नहीं है, इसमें केस एक बहुत सिंपल सा है। एक आदमी के डेथ का है कि वो 85 में मरा कि 87 में मरा। अब उसमें जो फाइट जो चला इन लोगों के बीच में म्यूटेशन केस चला, वो LRDC के यहाँ चला, AC के यहाँ चला और कमिश्नर के यहाँ चला गया। अब ट्रायल कोर्ट ने एक इशू फ्रेम कर दिया कि वेदर द ऑर्डर ऑफ द कमिश्नर वाज राइट और रॉन्ग। तो कमिश्नर को तो हजूर म्यूटेशन केस में कोई पावर ही नहीं था ऑर्डर पास करने का। दिस एस्पेक्ट ऑफ द मैटर ट्रायल कोर्ट ने उसको देखा नहीं और उसके बाद वो अफर्म कर दिया कि नहीं कमिश्नर को पावर था और कमिश्नर ने सही आदेश पारित किया। दिस वाज फाइंडिंग ऑफ द ट्रायल कोर्ट।
I am appealing for the response, leadership.
हम उस
The main issue is that whether the respondent one, defendant number one, was the son of the deceased father or not. That is the main issue. Whether he is entitled to claim the possession over the land or not. Main issue is that, leadership.
आज करना है कि कल करना है?
आज निकले हम अगला मंगलवार।
अगला मंगलवार को
इसलिए
कौन सा मुहूर्त निकाला?
मुहूर्त के बाद
2017 से ये केस चल रहा था। सेकंड
इसमें लर्नेड अपीलेट कोर्ट हैज रिकास्टेड द इशू फ्रॉम द स्पेशल इशू। उसमें अभी PW एक्ट के गवाही को हेवीली रिलाई किया है और एग्जिबिट सी
मेरिट का बात ही नहीं करते हैं हम। सुनेंगे ना आपको मेरिट
वही आज हम कर रहे थे। PW एक्ट और C और D जो एग्जिबिट मार्क हुआ है और एक एग्जिबिट 9 है जो वो मार्क हुआ है, हम उसी को लाने बोले हैं। जो खाली कागज देख लेंगे और उसी पे हम 2 मिनट का बहस करेंगे। अगर हम सक्सीड करेंगे, हम पूरा पढ़ चुके हैं, खाली वो कागज को देखना चाहते हैं क्योंकि पूरा इंटरप्रिटेशन उसी पे है। अगर जो अपलेट कोर्ट कह रहा है, क्योंकि मेरे हिसाब से हम म्यूटेशन फाइल की 85 के बाद और ये जो C और D इशू हुआ है वो 89 में हुआ। लर्नेड अपीलेट कोर्ट कंसीडर किया कि 1 साल के भीतर ही अगर कोई रजिस्ट्रार है ही कैन इशू सर्टिफिकेट। लेकिन मेरे केस में चूंकि हमने भी डेथ सर्टिफिकेट दिया और 2004 का था तो कोर्ट ने कहा कि 1 साल के बाद का है हम इसको नहीं मानेंगे। तो फिर 89 का भी नहीं मान सकते थे क्योंकि 87 में डेथ हुआ है। तो हमको ये 3 डॉक्यूमेंट देखना है। कंकरेंट फाइंडिंग है। ओनली 1 पॉइंट इसमें इन्वॉल्व है कि वो आदमी मरा कब और उसके मरने के बाद उसकी बीवी प्रेग्नेंट थी कि नहीं, क्योंकि आफ्टर 6 मंथ इन लोग का क्लेम है कि लड़का पैदा हुआ जिसके चलते वो पूरा प्रॉपर्टी इनहेरिट करेगा। और अगर उसके बाद हुआ, इतना सा छोटा इशू है जो मात्र 4 डॉक्यूमेंट पे है और PW एक्ट के गवाही पर है, उसको खाली हम देखना चाहते हैं। उसके अलावा हम तुरंत बहस करते हैं। उसी को बोले हैं जो मेरा फाइल में नहीं है, रहता तो हम आज ही बहस कर देते हैं। हम परसों से जब भी इसमें आया है हम तैयार हो रहे थे। फाइनली हमको लगा कि ये 4 डॉक्यूमेंट देख लेना चाहिए और 17 से इंतजार किया है जो एक सप्ताह और कर सकता है। इतना ही सब मेरा कहना है। और उसमें भी रॉन्ग में
बच्चा का इतना कहानी आप
नहीं जो प्रॉपर्टी है ना पूरा
वो प्रेग्नेंट थी कि नहीं थी,
वही है ना,
कब मर गया।
सेक्शन 112 बोलता है ना कि अगर 9 महीना 10 दिन के बाद आफ्टर डेथ अगर होता है तो उसका राइट नहीं बनेगा। अगर 9 महीना 10 दिन के अंदर होता है तो उसका राइट।
बात बताइए,
प्रॉपर्टी इनहेरिटेंस में
हस्बैंड के मरने के बाद प्रॉपर्टी किस,
अगर
हस्बैंड के मरने के बाद प्रॉपर्टी किस,
अब तो किसके कस्टम
बताइए।
अगर रॉ कस्टमरी राइट से चलेंगे तो वाइफ का
कस्टमरी राइट से कवर्ड है ये लोग।
हाँ
एडमिटेड फैक्ट है,
एडमिटेड फैक्ट है, वो दोनों पार्टी एडमिट करता है। तो वाइफ और उसकी बेटी थी तो दे विल हैव ओनली राइट टू मेंटेनेंस,
मतलब
प्रॉपर्टी पे राइट नहीं होगा। तो खाली एक इशू है, इसमें बहुत बड़ा इशू नहीं, बस वही 6 महीना और डेथ सर्टिफिकेट, इतना ही सब बात है। इसलिए वो 3 डॉक्यूमेंट और PW एक्ट चूंकि हमारा ही विटनेस है और वो कुछ बात को एडमिट कर लिया है, अगर वो कर लिया है तो आई हैव नो केस। तो उसी को हम देखने के लिए मांग रहे हैं। अगला मंगल को लगा दीजिए हम बस।
I will request on the council for the Vilan post this case on next Tuesday in the supplementary case to be taken up as first case as to.
हो गया,
नोट बनाइए।
नहीं पूरा तैयार सब बना लिए, खाली 3 कागज देखेंगे नहीं होगा।
इतना सुनने के बाद जो है ना अब तो केस ही डिसाइड हो सकता है, खाली रिकॉर्ड नहीं है यहाँ पर।
हाँ हो सकता है, वो 3 डॉक्यूमेंट हम ले आएंगे।
इसीलिए थोड़ा नोट बनाइए, अगर एडमिट करना होगा तो एडमिट करके 15-20 दिन में रिकॉर्ड मंगा लेंगे, डिसाइड कर लेंगे। इतना सुनने के बाद थोड़ी आपको बचता है,
नहीं इससे ज्यादा कुछ है ही
बस
नहीं।
सुनिए
ठीक हो गया।
सुनिए।
Item 17, second appeal 384 of 2019.
Paying for Passover for coffee cases. The senior counsel will answer.
Item 18, second appeal 389 of 2019.
This is plaintiff second appeal against judgment of responsibility. But it cannot be termed judgment of responsibility. The finding of trial court is peculiar. Entire finding with respect to title, possession, the unregistered sale deed, everything is decided in my favor. But in concluding part, it has been held by the trial court that my vendor had better title than me, who is not a party.
Vendor had better title than you.
Did not have a title, so therefore
Your vendor did not have a title.
did not have a title. Therefore, the sale deed, though it has been held prior, that sale deed is valid. We may be allowed to refer the finding of the trial court part. But the suit is for declaration of title and injunction restraining the respondent number 3 and 4 from interfering with our position. One Ratan Mathur, had converted some Jhadi jungle land as cultivable in 1938. And on 15/7/1940, he sold the land to one Kali Charan Lohar. Kali Charan Lohar was grandfather of plaintiff for ₹90 through Sada Sethi. Thereafter, Pakka boundary was constructed by heirs of Kali Charan Lohar, and they constructed a house also. It is also treated in the frame. Now let in survey operation of 1970-71, names of 4 tenants were recorded with respect to the land. Tisco, respondent number 4, filed objection.
This is dependent on what?
Yes. Thereafter, the land was recorded in the name of the state of Bihar with possession of plaintiff since 1981. Avaid Dagan since 1989. Division number 4 again filed objection.
1989.
89. Division number 4 again filed objection under section 89 for deletion name of plaintiff, which was rejected by the order dated order in case number 754 of 1991-92. And that record of right remained showing my name in Avaid Dakhal since 1989. There was a BPL proceeding against me, number 4 of 1991. That proceeding was dropped. After report, we were found in possession, the proceeding was dropped. And at that point of time, we were found in possession since more than 50 years. From more than 50 years, BPL proceeding. Division by court preferred appeal. The appeal was allowed. Ultimately, the judgment dated 17/9/2008 was challenged in writ application as well as in later patent appeal. In
This appellate order.
yes. In LPA 267 of 2006, this honorable court, while dismissing the appeal, restrained the defendant from demolishing the house. Why on the stretching on a house? because the appellate court says that land was met Korkar and it was purchased by Kalicharan. There was no house. Now, case of the state of Bihar, that record of right is correct. The suit belongs to defendant number 1, but the suit is back for non-submission of section 18 notice. I written the statement of this court. Defendant number 4 was that defendant number 4 with effect from 1/1/1956 are in possession by virtue of a lease deed executed by a state in favor of Tesco on
But the
28.
suit is barred by notice under section on account of non-furnishing of notice under section 88 CPC.
Even assuming that the record of right is correct, even assuming, therefore
No,
I was.
I'm on a different point altogether.
Pardon?
Suppose the suit is decided ultimately by saying that it is not maintainable.
No, no,
Or
no. It has
section,
not been decided so. Therefore, I was stressing on transport judgment.
which judgment?
Transport judgment. Every issue has been decided in favor of plaintiff.
Has it been recorded that you were in possession
Yes,
by
yes.
virtue of the register,
therefore,
unregistered sale deed?
My unregistered sale deed was held valid by the transport.
That's
I was in possession, it was held by the transport. My title is perfect, it was held by the transport. My vendor had made Korkar, the Jhadi land, jungle land. This is all held by the transport in favor of plaintiff.
then why the court has dismissed your case?
Therefore, I was saying, sometimes we are also confused. When everything is in my favor, can't they come to page running page 100, internal page 41 of the transport.
Yes, and then.
So thoughts of mine are let take it.
Huh.
5 lines from the bottom margin. I find and hold that the plaintiff has got a better title through inheritance.
Has got no
has
better
got no better title through inheritance and succession. The plaintiff has also failed to prove better title of vendor over the suit land by its conversion to Korkar. As such, I find and hold that sale deed executed by Ratan Mahto in favor of Kalicharan Lohar, Exhibit 1, is not valid document to confer right, title and interest for the suit land in favor of plaintiff. It is proved that the suit land is property of state of Bihar, Jharkhand and the lease of company in this court. The plaintiff has got no valid cause of action for declaration of this better title than confirmation of possession for Schedule C, the suit land. When the plaintiff miserably fails to establish prima facie better title over the government land, therefore he is not entitled for honor of permanent injunction disclaiming the state of Jharkhand and TISCO. Balance of convenience lies in favor of defendant. And
What is the finding of issue number 8?
Yes, that I want.
इशू नंबर 1 का फाइंडिंग देखिए मेरा प्रॉपर्टी कोई और बेच देगा तो आपका थोड़ी हो जाएगा
नहीं that my vendor is not coming forward.
So I just want to know, does the suit land belong to state of Bihar / state of Jharkhand?
Vendor
And
did
defendant number 4 is a lessee of the same.
The
Because defendant number 4 must also be claiming by way of registered deed
lease.
lease,
Yes, yes.
and the property must have been included in that lease.
This is the present dispute, and the trial court has come to a definite finding that I am in possession of this property since 1940.
Maybe you see there are people who are in these leasehold areas who are in possession of the property. That does not mean that the title of the
My sale deed was earlier also found by the trial court was valid, was a valid sale deed. Let where
Who was the executor of your sale?
the Korkar, the person was met Korkar Ratan Mato.
Does his name appear in any of the record of rights? Is there
That has
anything?
not come. That has not come.
If it has not come, so unregistered sale deed, and on the basis of Korkar you are claiming
Let
that.
the only record of right has come of 1971-70, and in which we
And your
were found.
possession has been shown only from 1989.
Yes, and in that record of right, we were found in possession Abhay Dakal since 1989.
89. So that is, there is a presumption.
Therefore, I make your permission to refer the finding of the trial court.
First, I want to see the finding with respect to issue number 8.
Yes. But we are referring internal page 15 of the trial court judgment, where all the issues have been quoted, and thereafter read para 9.
Yes, I'm there. No, it's a long paragraph. You just tell us where is the finding.
Yes, yes. Kindly come to internal page 36.
Yes, I am at internal page 19, para number 9B. Yes.
The witnesses of plaintiff have stated that vendor Ratan Mehta had acquired the fruit land by clearing forest and bushes from there and resides over the same with family. In the year 1940, Ratan Mehta sold the fruit land to Kalichar and Lohar through unregistered sale deeds upon consideration of Rs 90 only. Now it is clear that Ratan Mehta himself possessed the fruit land by removing bushes and forest from there, but the government has not regularized his possession through patta or any other relevant document of that time. There is no any document filed on case record to establish right title of the vendor Ratan Mehta in the year 1938 format. Therefore, his alienation and transfer of right title to Kalichar and Lohar in the year 1940 seems to be untrustworthy and does not inspire confidence of his better title. The plaintiff has claimed over the fruit land on the basis of alleged sale deed through inheritance and succession, but the original vendor Ratan Mehta was himself not having any title, right title and interest over the suit. Therefore, his alienation of right title and interest over the suit land to the grandfather of plaintiff, Kalicharan Roha, through unregistered deed of sale was not lawful and did not confer any better
This
title.
finding is clear.
Now let kindly come to ultimate finding. Yes, 36. 36. Only two paragraphs of page 36, internal page 36 and onward.
No, I'll come one by one. Please hold on. You please come to this para number 10 at page 25. So DW1 का जो
Yes.
evidence पढ़ी.
DW1, Pradeep Kumar is an employee of defendant number 4 Tisco Limited, working as land assistant, as stated through affidavit examination in chief that our RS plot number so-and-so, Khata number so-and-so was recorded as Anaba Malik during divisional service settlement of the year 1934-37. Further, this witness has proved all documents filed by the defendants. In cross-examination, he has stated that the plaintiff Mohan Loha resided over the suit land and has illegally possessed the same. Further, he described all the case filed by the defendant number 4 Tisco against plaintiff of this suit. The defendant number 3, Hindustan Petroleum Corporation, has also got some lease over some portion of the suit land after approval of DC Jamshedpur. The suit land has been acquired by state government in the year 1956 and it has been leased out to Tisco Limited after expiry of lease on 31/12/95. Again, it is renewed in the year 2005 but the government has accepted the lease rent in gap period which has been deposited by the defendant through treasury finance. This witness has reiterated that the plaintiff Mohan Lohar illegally possessed the suit land from the year 1989. Lastly, this witness has stated that the suit land stands under the lease of Tisco Limited. DW2. Sanjay Kumar Shukla, working as survey officer in land department of Tisco Limited since 1991. He has proved original certificate for delivery of possession dated 11/7/94 for sublease of an area 0.184 square feet from RS plot number so to MS Hindustan Petroleum Corporation Limited. This certificate of delivery of possession in favor of Hindustan Petroleum is marked Exhibit H. In cross-examination, he has declined to say anything regarding the suit plan and this case.
Now, after considering the documentary evidence,
See, this 83 proceeding was decided in favor of Tisco with
Yes,
respect to the
yes.
same property.
BPLD proceeding,
No, 83 under the CAT Act.
yes, decided in favor of Tisco
In favor
on
of
objection,
Yes,
and we were put in illegal possession. It
That's
is
right.
remarked for.
because you were in possession, therefore illegal possession. But the entry in record of right was challenged by Tisco.
Yes,
And then pursuant thereto, the illegal possession was shown since 1989.
yes.
That's it. So अब कुछ है नहीं ना सर.
नहीं कुछ है नहीं, लेकिन हमको एक चीज समझ में नहीं आया. When every finding of trial court is in my favor,
देखिए फाइंडिंग तो हम लोग स्टैट्यूट की तरह तो नहीं पढ़ेंगे, टोटलिटी में पढ़ेंगे जजमेंट. Heard that the council is pleading on behalf of the applicants.
my friend is suggesting that two important documents have not been considered.
Which document has
Just-
not been considered? Which could show your possession since 19.
Yes, sir. Yes, sir. Yes.
First is Exhibit 3 also.
What is
Page number
exhibit?
21, it has been discussed.
Page number 21.
21, internal page 21.
Exhibit 3.
Exhibit 3 is the certified copy of inquiry report in case filed by plaintiff Mohan Lohar against the state of Bihar Tisco under section 90 of CNT Act. During case number so and so, whereas after spot verification, it was reported that plaintiff's
It is
grandfather
of course use.
Just
इसका कोई relevance नहीं.
had
Report
purchased
में कुछ लिख देगा उससे थोड़ी कुछ होगा.
another
An exhibit.
Exhibit 10 also. Certified
Page-
copy of
page
page 22.
Yes.
Certified copy of order sheet of case number so and so under 89 CNT, which was filed by Tisco Limited against plaintiff Mohan Lohar for removal of illegal possession of the plaintiff. Learned Executive Authority has found that Tisco Limited has got no possession over the suit land even in the service agreement of the year 1971-72.
That's why Tisco might not be having
From
possession.
71,
But
72.
who was in possession is not recorded. It is not recorded that you were in possession.
My tenants were in possession also. That was recorded.
Second appeal में तो नहीं चल रहा. Second appeal number 389 of 2019.
Just a moment, Mr. Sani is suggesting something. You hold on.
Wrongly recorded in the names of the tenants, an objection was raised, and that objection was also, there was just see exhibit 10 my friend was reading.
Just a minute.
Certified copy of order sheet of case number 745 by 9192 under section 89, which was filed by Tisco against the entry, against the plaintiff Mohan Lohar and Bihar Sarkar, because there was illegal possession was recorded in favor of the plaintiff. That is the reason 89 was filed by the Tisco to delete the name.
That's right. And ultimately that order
And
was
then the
passed.
landed executive authority has found that Tisco has got
Yes.
no possession.
89 का तो अपना अपील चलता है.
Then is 89 का फिर
अब 89 का अपील चलता है ना अपना.
तो उनका फिर अगेंस्ट में क्या टिस्को का तो अपील क्यों
Against में कहाँ गया?
दिखा जाए
इसको क्या
पढ़ा लीजिए पढ़िए
It was only pursuant to 89 order.
The-
Your illegal possession was shown from 1989. या कोई particular
that
date
is
से.
continuing since the last cadastral survey
So,
and that
so
was the
therefore,
continuation.
so therefore, pursuant to this 89 order, your possession has been shown since 1940.
Yes, but that is in possession, not
Where is the document which shows your possession since 1940?
yes, that is pursuant to
Which is that document?
pursuant to
Exhibit.
exhibit 1. Exhibit 1 most probably if I recollect. If Lordship may kindly see page 79. In our page 20.
Yes.
This alleged sale deed through which the plaintiff has claimed his inheritance and succession of the suit land. The sale deed is written in Bengali script. However, the plaintiff has filed English translation of the same without any objection from the defendant. It is emphasized under English translation of the sale deed that Ratan Mahato was Raya for the suit land, but there is no any explanation that how he became Raya of the suit land and from where he acquired the right over the same. All the plaintiff
Which
witnesses.
day, Mr. Sani, आप
The Lordship may kindly see
अच्छा,
15/7/1940. 15 July 1940 is the date. The unregistered alleged sale deed that was for value 90 rupees. So it was not required to be registered. And the findings of the learned trial court in favor of the plaintiff. The Lordship, I will show from my senior. The unregistered alleged sale deed was executed on 15/7/1940 in presence of two witnesses, namely Narhari Mahato and Bhola Bhumi, but evidence of those witnesses could not be adduced by the
You see, the vendor did not have the title. Show me that the property was recorded in the name of the vendor in any of the survey settlements. Was it recorded in the name of
That is
the?
the reason, Virat. The case, the point was raised is Korkar. And Korkar
Merely because a person is doing Korkar, the property
since
automatically.
1940.
Maybe since 1840.
And therefore,
Then the
possession was
property.
recorded.
Then the property does not automatically gets. He does not automatically becomes a rayat unless his right as a rayat is recognized by
Yes.
Zamindar or by the state or somebody.
By the Jamindar.
Where is that?
Your
Where is that
Excellency,
his right was recorded, was acknowledged by the Zamindar? बताइए जमींदार सेटल कर दिया कोर्ट करने के बाद
पैरा 9C में रिपोर्ट किए हैं plaintiff has also pleaded para 10A of the claim that he acquired title of this woodland through adverse possession
Adverse
since
possession का
1940.
एडवर्स पोजीशन तक आपका प्ली रिजेक्ट कर दिया है
नहीं रिजेक्ट तो गलत किए ना 1940
अब
से
आप एडवर्स पोजीशन में आ गए
नहीं
टाइटल से शिफ्ट हो गए अब एडवर्स पोजीशन का काम
alternative that plea was alternative that is
You
para
can't
10A.
have both the pleas simultaneously. That is not permissible under law.
हुजूर ये
Once you are claiming the title by virtue of a deed of sale,
Yes.
and then you will also claim adverse possession from 1940 on the basis of the same document.
Exhibit 1 is beyond rupees 90 was the value. It was not required to be registered.
You say
So
since
that is the
1940.
title deed.
There has been so many survey settlements, right?
That is the reason of the last survey settlement 1989, which was done.
It has been ultimately recorded
In
from
the name of
1989.
my possession.
Since 1989.
99 it was recorded.
No. It has been recorded since 1989.
1989.
That is the date of your possession,
That
as
was
per
in
the
con-
record of rights.
In continuation of the possession.
In continuation कैसे?
Of the possession of 1940.
कहाँ से पढ़ रहे हैं?
On the basis of
Mr. Sani
sale.
जबरदस्ती पढ़ रहे लगता है आपका litigant
Most
भी बैठा हुआ
house.
देख रहा है.
क्योंकि हम conduct के
नहीं कंडक्ट किए होंगे
इसीलिए हम
लेकिन
ये
रिकॉर्ड
इसलिए हमारे दिमाग में जो बात था वो हम वही याद दिला रहे हैं।
आप जो आपके दिमाग में जो बात था वो ऑर्डर से नहीं
ऑर्डर से मिलेगा तो जो देखा जाए कि ट्रायल कोर्ट का जजमेंट माननीय सीनियर हैज ऑलरेडी रेडी ट्रायल कोर्ट का जजमेंट में ये सब होल्ड किए हैं एंड दैट हैज बीन रिवर्स
आपको तो बोल रहे हैं ना आप हमको एक डॉक्यूमेंट दिखाइए which says that you are in possession since 1940. I will immediately frame the question of law that the judgments are perverse on account of non-consideration.
ट्रायल कोर्ट का जजमेंट
दिखाइए.
मैं हुजूर पेज 21 अगर देखेंगे पेज 20 अल्टीमेट फाइनल बोलते हैं that thus to my considered view the dominant question for adjudication as to whether the plaintiff, appellant, or his predecessor in interest and had acquired any right, title, or interest in respect of the suit land, and by virtue of Exhibit 1 is decided in the negative. And the incidental question as to whether Ratan Mahato had acquired total right over the suit land is also decided in the negative, holding Exhibit 1 is not a genuine document. This is the finding of the learned appellate. Now, your lordship may kindly come to trial court judgment. Trial court judgment will take 1 minute देखा देते हैं, उसके बाद I will not take much time. Your lordship may kindly come to mirror after discussion of all the documents, case of the plaintiff. Lastly, your
पेज
lordship may
नंबर
kindly come to page
अभी एपीलेट कोर्ट का फाइंडिंग कहाँ पढ़े आप? पेज नंबर
19.
नहीं, आपका पेज नंबर टैली नहीं कर रहा है ना, इंटरव्यू पेज बताइए।
Substantial question.
नहीं, पेज नंबर
Sorry, page 21.
पेज 21 कमिंग टू द अदर इश्यूज।
वो आ रहा है पहले दी फाइंडिंग दी अपरेट को मेरे अगेंस्ट में पेज 21 running
Yes.
page 54.
Yes.
Now Lordship may kindly come to page 31 of the trial court judge. On the point of transfer of said land by Ratan Mahato to Kalicharan Lohar. Kalicharan Lohar was the father of this. Now you will see this submission. Then on the point of possession, the factum of possession of our schedule such and such. Upon death of Kalicharan, page 32, father of the plaintiff and thereafter the plaintiff inherited the suit land and first possession of the plaintiff through his
आपका
ancestor.
पेज नंबर तक नहीं पहुंच रहा। अपॉन डेथ ऑफ कालीचरण
पेज 31 पढ़ रही है।
यस यस ठीक है।
उसके बाद हमें पेज नंबर
32 में टॉप में
वही पढ़ रहे थे। Upon death of Kalicharan Lohar, father of the plaintiff and thereafter the plaintiff inherited the suit land and first possession of the plaintiff through his ancestor over the suit land is continuous, uninterrupted, and within the full knowledge of the defendant number 1 to 4 since 15/7/1940. This is the finding. Then we have Roman 4, entry of possession.
This is not the finding.
Your Lordship,
This is just the evidence discussion. This is not the
this is
finding.
the observation of the
No,
learned
no,
trial
not
court.
the observation. This is not the.
This
This
is
is not the
recorded.
finding of the court.
Then your Lordship may kindly see
That
after
is not the
the.
finding of the court.
Then your Lordship may kindly see after legal submission.
And legal
Page
submission
34
number 1
onwards.
court का right.
Page 34, total right,
यहाँ
section
से शुरू
64.
होता है।
Then your Lordship may kindly see the last part, page number 36. Page number 36. In view of the aforesaid legal backdrop, it is crystal clear that Ratan Mahato, being villager of village Sonari, where the suit land situate, converted the barren land into cultivable land in 1937-38, and therefore he acquired an occupancy right and became absolute right and title holder, and thus rightly sold a portion thereof to the grandfather of the plaintiff by virtue of a registered by sale deed for a value of ₹90, which is less than ₹100. This is finding. This is finding, and that has been reversed by the learned appellate court without meeting all these points.
All these
After
points-
discussion, that is my submission.
As well as the lower appellate court has committed error of record also.
Yes.
In pleading, there is a specific statement made that after purchase, they constructed a house, boundary wall, etc.
Then Roman 3 also admittedly since 15/7/1940, the grandfather of the plaintiff came in peaceful possession over the suit land, and upon his death, the same devolved upon the father of the plaintiff, then to the plaintiff. This thus continuous and in uninterrupted possession of the plaintiff over the suit land since 1940 remained undisputed. So mere entry since 1989, that has also been taken into consideration by the learned trial court. These are the findings.
Therefore, that I submitted that sometimes we are also astonished by seeing such type of judgment. Every issue has been decided in favor of plaintiff.
the question of law concerning
ABC. It is at page 26.
Listen up.
the appellate court has not discussed the trial court judgment.
Whereas he has denied even exhibit 1, the sale deed. It is forged and fabricated.
No discussion.
Regarding building, there is a specific pleading in para 5 of this case. It was also not accepted by the trial court. In para 3 of the case,
Lordship, in the para number 9 of the appellate court judgment, they have discussed finding of the court below, wherein it is said, then internal page 8 of the appellate court order.
Para 9.
Para 9, Lordship.
Please kindly read it.
The trial court took up the issue number so and so and so and so, the maintainability of the suit, the validity of cause of action, question of sale deed by Ratan Mahto in favor of Kali Charan Rohar, and the question as to whether Kali Charan built a pakka house over the suit land, and finally the question as to whether suit land belongs to the state of Bihar with TISCO as lessee for adjudication on the priority basis. While discussing these questions, amalgamated with the question of adverse possession, discussed the oral and documentary evidence available on the record, including written notes of argument, which was filed on behalf of the plaintiff appellant, which has been copied verbatim in the judgment, which particularly created the confusion as to whether it is the argument of the plaintiff appellant or it is the finding of the court below. So, Lordship,
Kindly read it.
but on a close scrutiny of the wording, it is apparent that the court below has copied the written notes of argument filed on behalf of the plaintiff appellant, and finally, at para number 12, came to the conclusion that the predecessor in interest of the plaintiff appellant, namely Ratan Mahto, had not made the land as a conquer land by cultivating a flow land recorded as a waste land, and then the said conquer land was transferred by virtue of sale deed, which though was not registered, but under law also the same was not required to be registered, holding that the plea of conquer was beyond the pleadings and that no question of adverse possession arises, and the sale deed was also considered not to be the genuine document. The court below considered that land was recorded as Anabar Bihar Sarkar having lease right with school limited, and since the vendor of the plaintiff was not considered to have acquired the right of occupancy, hence sale deed was also considered to be inconsequential, and thus the court concluded that plaintiff appellant had failed to establish any better title of land compared to that of government and finally decided all the issues against the plaintiff. Consequently, issue number so and so were also decided against the plaintiff and suit were dismissed on contest, however without cause.
Where is the finding of the learned trial court that this scorecard did not happen? Is there any finding of the trial court?
Yes, this is the finding that learned trade has read out. It is finding of the court.
The appellate court says that we also find that it is absolutely mixed. वो बोलते हैं कि written notes of argument का copy paste करके judgment बनाए। बोल तो यही है।
Person been para.
Yes. Who is this judge? Written notes of argument का copy paste करके judgment बनता है। It's very serious. We can't ignore it. It is something which is extremely serious.
That is the observation of the learned appellate.
Yes, yes. वो तो record देखेंगे ना?
हाँ, उसको record देखने से
देखना ही पड़ेगा ना?
जी।
Written notes of argument का क्या हाल बना है?
Written notes of argument का finding नहीं हो।
ऐसा तो नहीं है ना कि हम लोग practice नहीं किए हैं।
Written notes में जो लिख दिया वो उतार दिए सो बात नहीं है। आप मंगा के देखिए written notes सामने से देखिए। तो सभी नहीं है। अभी तुरंत नहीं है। तो नीचे को बताया हुआ।
Finding of appellate court begins from page 7, para 50, page 70.
मत बोल दो, यहाँ नहीं बोल रहे। written notes से क्या?
The main question raised by the appellate court
Just a moment.
is at page 21.
Please hold on just a moment. आप ये इस फाइंडिंग को जरा फोकस करिए। पेज नंबर 40 of the trial court judgment, running page 99. Page number 40.
40.
Internal page 40, running page 99.
D.
ये 12C के बाद admittedly dash शुरू होगा।
हाँ.
Admittedly.
Admittedly, the suit land has been recorded as Anabad money since 1931, having reached right to company Tisco Limited. In plain plaintiff has pleaded
Just a
that-
moment. This property formed a part of fiscal lease even in 1931. Correct?
That is the record also, because after vesting,
Record क्या? इसमें admittedly लिखे तो गलत लिखे हैं।
that is there. चलो उसमें 1950 के बाद
आगे पढ़िए।
Tisco in plain plaintiff has pleaded that vendor Ratan Mato has acquired the suit land by clearing the forest and bushes from there. But at the time of argument, and lawyer on behalf of the plaintiff taken a new fact that the Ratan Mato had converted and acquired the Rati over the same through Porker. Both the pleadings are contradictory in nature. Moreover, neither the plaintiff nor defendants have laid evidence in respect of the process of conversion of the suit land as Porker. Plaintiff has also not proved the fact that subsequent relevant documents in favor of Ratan Mato. Admittedly, neither Ratan Mato nor plaintiff nor his predecessors and interests have ever paid rent for the suit land, and the state government has also not regularized the possession through valid document. Admittedly, in 1971, during survey settlement, the name of different persons entered into the record of rights to whom the plaintiff claimed as his tenant, but later on it has been rectified by the state government. Admittedly, the plaintiff Mohan Loha has been shown under the illegal possession over the suit land in recent survey settlement exhibit 15, and thereafter several litigations with the state of Jharkhand and company Tisco Limited. The plaintiff claimed his possession since peaceful, undisputed, and uninterrupted since 15740 through his predecessor in interest. But Exhibit 15 record of right, they prove that he possessed the woodlands illegally since 1989. There shall be presumption of correctness for the record of right. Moreover, the plaintiff himself proved through documents and his possession is not uninterrupted, rather interrupted and intervened by the state of Jharkhand as well as the company Tisco Limited. Possession of the plaintiff is not peaceful, actual, uninterrupted, hostile in the knowledge of the true owner, the state of Jharkhand, and lease holding company Tisco Limited. If I pause for a moment, in 1931, no state of Jharkhand, no state of Bihar. And what the learned, that is the I submitted for lordship, that is an error. In 1931, there was no state. And 1971 entry has not been undisputed. 1971 recorded in the name of the tenants, and the dispute raised and that was correction was made in 1971. So after 71, in 1989 another revision of survey. Then 1989 it was recorded in the name of the plaintiff. It is in continuation. The findings already recorded earlier that is a finding, and the learned appellate court in one sentence said it is taken out from the written note. That is of course it is a perverse one. Written note will not show that this has been recorded in this way.
That's all.
Okay, sorry, not I interfered in between because
नहीं अच्छा कि ज़्यादा क्लियर हो गया क्योंकि कंडक्ट किया हुआ था इसलिए
Heard the learned counsel appealing on behalf of the appellant. This appeal has been filed against the judgment and decree dated 25/9/2019 within bracket decree signed on 7/11/2019 bracket close, passed by the learned Principal District Judge ECU Jamshedpur in Civil Appeal number 59/55 of 2018, affirming the judgment and decree dated 1/8/2018 within bracket decree signed on 10/8/2018, passed by the learned Civil Judge within bracket Senior Division bracket close Roman 2 Jamshedpur in original title suit number 37 of 1996. The learned counsel for the appellant has submitted that the learned trial court, while dismissing the suit on the one hand, at various places has recorded the findings in favor of the applicant. He has submitted that the learned trial court has recorded in internal page 32 that upon death of Kali Charan Lohar, father of the plaintiff, and thereafter the plaintiff inherited the suit land and thus possessed the plaintiff, and thus possession of the plaintiff through his ancestors over the suit land is continuous, uninterrupted, and within the full knowledge of the defendant number 1 to 4 since 15/7/1940. The learned counsel further referred to internal page 36 and has submitted that a finding has been recorded that in view of the legal backdrop, it is crystal clear that Ratan Mehto, being villager of village Sonali, where the suit land situates, converted the barren land into cultivable land in 1937-38, and therefore he acquired occupancy right and became absolute right and title holder, and thus rightly sold a portion thereof to the grandfather of the plaintiff by virtue of sale deed for a value of rupees 90, which is less than rupees 100. And further recorded a finding that in internal page 37, that mere entry in record of right that the plaintiff is in illegal possession over the suit land since 1989 cannot wipe out the possession of the plaintiff since 1940. The learned counsel for the appellant has submitted that in spite of such clear finding recorded by the learned trial court, the suit was dismissed by holding that the vendor Ratan Mehto had not acquired better title over the government land, which was under lease of Tisco Limited, and there was no question of his devolution to the father of the plaintiff after his death to the plaintiff. The learned counsel submits that the learned first appellate court has ignored the findings recorded by the learned trial court and has affirmed the judgment of the and has dismissed the appeal, and accordingly it is submitted that a substantial question of law be framed and the appeal be admitted. Though at this stage there is no requirement to hear the counsel for the state, we are for the state?
Yes, boss.
As the substantial question of law has not yet been framed in the second appeal. However, the learned counsel for the state has referred to paragraph 9 of the appellate court's judgment to submit that the judgment of the learned trial court has been discussed by the learned first appellate court, and the judgment of the learned trial court be seen in the light of such discussion. After hearing the learned counsel for the appellant, this court finds that the plaintiff claimed that prayer क्या था सूट का? This court finds that the suit was filed. Yes, and this. The suit was filed for the following relief. ये आप ट्रायल कोर्ट का डिग्री है, पेज 105 में आपको उसमें मिलेगा. Okay. The case of the plaintiff was that all piece and parcel of land measuring 0.3430 hectare. That the Schedule A property was recorded in recent survey plot number 3222/6084 and 3222/6829 under Khata number 622 of Moza Sonali of Ward number 1 Jamshedpur, notified area committee corresponding to portion of revision survey plot number 455 of Khata number 77. And the Schedule C property was the subject matter of the suit. It was asserted that in division survey operation, Schedule B property was portion of RS plot number 455 of fallow land recorded as Anabad Malik in bracket Tisco Limited with a total area of 9.72 acres. It was the specific case of the plaintiff that one Ratan Mehto, a resident Rayat of village Sonali, converted the said land of Schedule A into cultivable land in the year 1938 and was in cultivating possession of the same. Thereafter, Kalicharan Lohar, grandfather of the present plaintiff, who was also a resident Rayat of village Sonali, purchased the property in Schedule A by virtue of an unregistered deed of sale dated 15/7/1940 for a consideration of ₹90 only and put him in possession. It was further case that while in possession, Kalicharan had constructed a house over the Schedule A property, which upon his death devolved upon his son, Dhiren Lohar, and grandson Mohan Lohar, the present plaintiff. It was also asserted that the property was in possession of the plaintiff / their predecessor in interest adversely and to the knowledge of the defendant number 1 and defendant number 4. And thus the plaintiff also claimed adverse possession. The plaintiff claimed that in the year 1968-69, the plaintiff had inducted 4 tenants in the house. And during survey operation of 1970-71, the Schedule A property was wrongly recorded in the name of the plaintiff's tenant, to which the defendant number 4 filed a case under section 83 of the Tobacco Tenancy Act, being case number 954 of 86-87 against the said tenants, where the plaintiff was also informed that the land is recorded, where the plaintiff was also informed, but the assistant settlement officer recorded the land in the name of State of Bihar with illegal possession of the plaintiff since 1989. Thereafter, defendant number 4 again filed a case under section 89 of the Tobacco Tenancy Act against the plaintiff for deletion of his name, but the prayer was rejected. The case was registered as case number 754 of 9192 for suit plot number 3222/6084. Defendant number 4 also filed another case under section 89 of CNT Act with respect to plot number 3222/6829, which was said to be pending before the Commissioner for the Nagpur Ranchi. The cause of action arose when the plaintiff came to know that the father of defendant number 2, who was defendant number 2? Father of defendant number 2 had filed an application before the defendant number 3 for grant of license to deal with petrol and diesel over the suit property, and the same was granted to him. But before any service station was opened, defendant number 2's father died, and defendant number 2, in consultation with defendant number 1, were trying to take forcible possession of the suit land by allowing defendant number 3 to build a service station and small office on the suit land for defendant number 2. Consequently, the suit was filed. It was a specific case of the plaintiff that they were in actual possession. They were in actual physical possession of the suit land by constructing a residential house, and since more than 40 years on the basis of unregistered sale deed dated 15/7/1940, and therefore the defendant number 2 and 3 could not take forcible possession. It was also asserted that the name of state of Bihar and possession of FISCO by virtue of lease are incorrect. The plaintiff claimed that they have also acquired right over the suit property by way of adverse possession. The defendants filed written statement. And disputed the claim of the plaintiff. It was alleged that the unregistered sale deed, if in existence, must be fabricated and manufactured by plaintiff. It was also asserted that Revisional Survey plot number 455 under Revisional Survey Khata number 75 of Moza Sonari measuring 93.32 acres was recorded in the name of Anabad Malik Khata during Revisional Survey settlement of 1934-37, and during the current survey as per the order passed under section 83 of Nagpur Tenancy Act, the name of Bihar Sarkar under lease of Tata Iron and Steel Limited with effect from 1/1/1956, and illegal possession of Mohan Lohar since 1989 has been recorded. It has been also asserted that some plot has been, some portion of new plot number 32222 has been recorded in the name of Bihar Sarkar and Tata Iron and Steel Company lease with effect from 1/1/1956, classified as Shauchalaya. It was also asserted that, as a matter of fact, Suit land along with other land was acquired by the then provincial government through the provision of Land Acquisition Act 1894, and the title and possession of which was delivered to the defendant. It was also asserted that in the Revision Service Settlement of 1934-37, the Suit land is recorded in the name of the defendant in its Anabad Malik Khata or plot number 455 of Khata number 77. The following issues were framed for purpose of consideration, and the findings in connection with support karna hai following issues. Findings in connection with issue number 1, 2, 6, 7 and 8 were said to be recorded under paragraph 8 onwards. The learned trial court recorded case of the respective of the plaintiff right from paragraph 9 and also referred to the various exhibits which has been relied upon by the plaintiff. And in paragraph 10, the case of the defendants and the various exhibits have been discussed. Then again, case of the plaintiff has been discussed in internal page 28. And further, the case of the defendant has been, defendant number 1, State of Bihar, has been discussed in internal page 29 of the trial court judgment. Then at internal page 30, the written statement of defendant number 4, Pisco, has been discussed. Thereafter, the evidence of the plaintiff has been discussed. And it has been recorded in page number 32. As under. So quote them. Then again, the documentary evidence of the plaintiff has been considered. And the legal submission, the consideration of legal submission starts at page number 34. And then in page number 36 and 37, following has been recorded. The perusal of the legal submission reveals that the recording in page number 36 and 37, the perusal of the judgment reveals that the recording in page number 36, 37 and so in 32, 36 and 37, is essentially relatable to the submission of the plaintiff. The findings actually starts from paragraph 12 of the judgment. By discussing, this court further finds that paragraph 12 upon perusal of the aforesaid findings, this court finds that it has been clearly recorded by the learned trial court under paragraph 12 within bracket C that the suit line was recorded as Anabad Malik since 1931, having lease right to company Disco Limited. In the plaintiff had pleaded that vendor Ratan Ram had acquired the suit land by clearing forests and bushes from there. But at the time of argument, the lawyer for the plaintiff had taken a new fact that Ratan Mehto had converted and acquired valid royalty right over the same through court card. The court recorded that both the pleadings are contradictory in nature. Further, the court also recorded that neither plaintiff nor defendants have led any evidence in respect to the process of conversion of suit land as court card. The plaintiff has also not proved this fact by subsequent relevant document in favor of Ratan Mehto. It was an admitted fact that neither Ratan Mehto nor plaintiff or their predecessor in interest have ever paid rent for the suit land, nor the state government has regularized their possession through a valid document. It was also recorded that admittedly in the year 1971 during survey settlement, the name of different persons were entered in the record of right to whom the plaintiff claimed as his tenant. But later on the entry was rectified and admittedly the plaintiff was shown under illegal possession over the suit land in recent survey settlement exhibit 15. The court recorded that the plaintiff claimed to be in peaceful possession since 15/7/1940, but the record of right showed that the possession was since 1989. The court ultimately recorded that the plaintiff has also failed to prove his title by way of adverse possession. The court ultimately recorded that the plaintiff failed to prove better title of the vendor over the suit land by its conversion to court card, and ultimately held that the sale deed executed by the vendor Ratan Mehto in favor of Kalijar and Lohar was not a valid document to confer right, title and interest over the suit land in favor of the plaintiff. The learned court also recorded that it was proved that the suit land is property of state of Bihar / state of Jharkhand and the lease of the company Tisco Limited, and that the plaintiff had miserably failed to prove his case and dismiss the suit. The learned first appellate court has also considered the materials on record and recorded in paragraph number 16 that the dominant question for adjudication was as to whether the plaintiff / appellant or his predecessor in interest had acquired any right title in respect of the suit land by virtue of Exhibit 1, which was decided in the negative, and the incidental question as to whether Ratan Mehto had acquired court-card right over the suit land was also decided in negative, holding that Exhibit 1 was not a genuine document. Concept paragraph of the temple, para number 9. By dealing with the judgment passed by the learned trial court, the learned first appellate court recorded in paragraph 9 that the findings of the trial court were confused and it was not able to and substantially was quoted from the written notes of arguments. It was furnished before the learned trial court. However, the learned first appellate court, after considering the materials, has arrived at findings from paragraph 16 onwards, from paragraph 14 onwards. During the course of hearing, specific query was put to the learned counsel for the appellant as to whether, apart from unregistered deed of sale dated 15/7/1940, there was any material on record to show that the vendor of the plaintiff was in possession of the suit property since 1940, to which no positive response has been given. Rather, the records, the impugned judgments clearly reveal that there is no material on record even to suggest that the vendor of the plaintiff was in possession, had done court car and thereafter the property was given to him by the state through any instrument, or that he was even in possession of the suit property. Both the learned courts have discussed the materials on record and have given concurrent finding that the unregistered sale deed dated 15/7/1940 was not a genuine document. The record of rights and other materials placed on record also revealed that also falsified the case of the plaintiff that his predecessor in interest had done court car and was in possession of the suit property since 1940. Or even prior to that. This court finds that both the courts have this court finds that the plaintiff has miserably failed to prove his case and the property was under Tata lease given by the state in their favor. And it was an admitted fact that the suit was recorded as Anabad Malik since 1941, having lease right of the company Tisco Limited. This court finds that this court is of the view that no substantial question of law is involved in this case, which is accordingly dismissed. Orders defective.
From supplementary list for orders be defect item 3. First appeal filing number 1591 of 2025.
The learned counsel for the would
For applicant.
for the applicant. As in case there is a standard order amendment. Time till 9th January. Or 16th January.
16 January.
Time till 16th January is granted to the applicant to remove the surviving defects or to file any appropriate interlocutory application in connection with one or the other defects. If this order is complied, post this case under appropriate heading on पिछली बार हमने कौन सा डेट दे रहे थे? 15 February. On 16th of February.
Item 4. First appeal filing number 1592 of 2025.
16th February. If you remove the defect, otherwise it will be dismissed.
Regarding the court case, we can file IA.
If you have anything to say in connection with any of the defects, you have to file IA. If you don't file it, the case will be dismissed.
Item 5. First
और
appeal.
IA फाइल करके within time उसको लिस्ट करा देना, नहीं तो आपका केस डिसमिस हो जाए.
Item 5. First appeal filing number 2305 of 2025.
From 5 to 26,
5 to 26.
26. Well, there is one exemption application I have filed that certified copy of the lead case. There are altogether 59 copies we have filed.
59.
Yes. So the difficulty was that even stamp reporting was not applicable because there was some defect in the award. Land acquisition case, their land reference case is mentioned.
Yes.
So the certified copy was to be transmitted to the law trial court. So some of has been transferred, but we are not updated. Then second law was not. We made a representation before the start for this. Now these 21 cases, stamp reporting so far as court fee is being paid. But my submission is that since it is arising out of the common judgment so far.
Which is that judge? Which is that case where the corrected certified copy is there?
Corrected certified copy award. For all award for different cases is prepared differently.
That's right.
So judgment is common valid for all.
Okay.
So there I have paid for exemption that one I have filed certified copy that will be taken for others.
That's right.
So
You
that
have
is
filed an exemption.
yes, valid and the
In all the cases.
in all cases I have filed.
Which is that idea?
Yes. Numbers will be different. But one limitation also is there.
272.
थोड़ा ना ये exemption का
The lead case where we have filed certified copy, that is filing number 2325 of 25.
filing number 23
of 25.
of 25.
Yes.
It is still defective.
It is because there the stamp reporting from court fee has not been done. And they say that now I will be sending to trial court for the purpose of removal of the defect in the certified copy of the award. Only when we pay the court fee.
They say that the suit value and appeal value is not mentioned. शायद यही
No,
रहता है।
ये नहीं है।
उसके अलावा भी है।
आज लैंड एक्विजिशन केस की जगह वहाँ लैंड रेफरेंस केस अवार्ड में लिख दिए। जजमेंट में तो ठीक चला।
आप हमको सारा वो फाइलिंग नंबर का क्या डेट है?
फाइलिंग नंबर
ये 2325 और 25 अभी तक लिस्ट में नहीं आया।
नहीं आया ना डिफेक्ट है ये लिस्ट
आप हमको
हमारा
पता है ना सब एक साथ लिस्ट
सब लिस्ट है
और सब कॉमन ऑर्डर से
yes because now certain act has to be done by the office
No, we will do it. Office will
this is the list of the cases
list of the cases arising out of the same judgment.
same judgment this entire
59 cases.
yes
Learned counsel for the applicant ASDI is present. He submits that arising out of the same impugned judgment
that is there
as many as 59 cases have been filed.
yes
सारे हो गए? कुछ बचे हैं?
नहीं सारे
59 cases have been filed. He has furnished a list of such cases.
yes
Office is directed to and he submits that all the cases be tagged.
maybe
We tag all the cases.
yes same issue same
We
fundamental
will tag all the cases. All the cases be tagged and appropriate order be passed in connection with removal of defects.
and condemnation of delay is also there
Removal of defects in these cases.
yes
He submits that in all these cases there is a petition for condonation of delay as well. Delay कितना है?
10-12 दिन
The delay is around 10
it will take to 20 because 5
to
6
15 days.
इसमें 13 days is first case
Delay is less than 30 days.
yes because we started filing with 5-6 lot we started there
आप कौन है?
state
State. Office is directed to place all the cases as furnished in the list. ये जितना है ना सबका फाइलिंग नंबर आप डाल देंगे. All the following
ये
cases.
चीज और इंडिकेट कर दें जैसे कि कोर्ट फी भी इंडिकेट कर देंगे ना तो हम जमा कर देंगे अभी जैसे कुछ केसेस में अभी सेकंड टाइम लावा जमा लगा रहे हैं आई फाइल इन मार्च आई वाज पोस्टिंग लाइक एनीथिंग बिकॉज़ एग्जीक्यूशन इज पेंडिंग देयर तो कोर्ट फी इंडिकेट नहीं कर रहा है कि अभी कुछ केसेस में
आपको खुद कैलकुलेट नहीं आता.
नहीं 21 नहीं अवार्ड है ना तो वो कर हम भी करेंगे तो 21 का किए हैं नाउ वी हैव स्टार्टेड डिपॉजिटिंग ये 21 जो आज लगा है और का नहीं किए तो ऑफिस कर देते तो हमारे लिए बिकॉज़ दिस इज एक्सचेकर्स मनी हैज टू
Could be mentioned. इसमें इनका अवार्ड में भी कोई डिफेक्ट है.
अवार्ड में क्या है ना कि एक्विजिशन केस नंबर जो है ना और जो उसके बाद एक हम फाइलिंग से फाइल किए हैं अवार्ड देयर दे हैव मेंशनड एलआर लैंड रेफरेंस केस
ओके.
जो होना चाहिए था
LA case.
एलए केस होना चाहिए था वो डिफेक्ट के कारण ये अटका हुआ है अभी और ये करेक्शन के लिए उनको भेजना है वहां पे भी है
एन ब्लॉक भेज पाते.
हां
एन ब्लॉक भेज पाते.
टाइम ब्लॉक चला जाए हमारे लिए तो
सारा का सारा एन ब्लॉक.
yes yes I am ready to argue only quantum is the issue and how the court has taken into consideration
उनको बोलेंगे ना कि जितने भी केसेस हैं जो भी डिफेक्ट पॉइंट आउट हो सकता
हाँ,
है
yes.
इससे related, ठीक है, इससे छोटा सा डिफेक्ट छोड़कर इस तरह से नहीं स्टैम्प रिपोर्टिंग करना चाहिए। एक डिफेक्ट निकाल दिया, बाकी जो निकाल सकते हैं उसको भी नहीं निकालना।
और फिर सेकंड लॉ से बात
Not
करना
like that, ठीक है। जैसे सर्टिफाइड कॉपी नहीं फाइल किया तो लिमिटेशन नहीं पता चलेगा, है ना, लिमिटेशन।
तो हम उसी पे
लेकिन डेट ऑफ फाइलिंग से तो पता लग जाएगा एट बेस्ट।
yes
ये
in my idea I have mentioned, in every idea I have mentioned.
30/11/24 का जजमेंट है, दिस हैज बीन फाइल्ड।
नहीं, उसके बाद हम सिक्योर किया ना सर्टिफाइड कॉपी का, वो एग्जेम्प्टेड पीरियड मिलेगा, हम बैक साइड ऑफ द सर्टिफाइड कॉपी विल रिवील दैट। इसमें नहीं है ना, दूसरे में है ना, तो हम आई हैव मेंशन मैंने, सपोज आई हैव फाइल्ड विद द सर्टिफाइड कॉपी ऑन 10th, some cases I have calculated, I have filed some on 12th, I have calculated, so it will be within the bracket of 20-25 days. In a span of 10 days I have filed all the cases.
The learned counsel has ये सारे cases को एक साथ लिस्ट करना। The learned counsel has also cited that in all the cases there is a petition seeking exemption from filing the
Certified except for filing number
2325 of 2025, in which certified copy of the impugned judgment
is there.
has been filed, and in the same case the delay is about 30 days.
30 days, we are
30
calculating
days.
30 or 40, because that is 5 we are not having. 30.
1 delay is around 15 days.
Yes, yes.
Around 15 days. Office is directed to place all these cases. Tag कर दीजिए, सबको tag करिए तो, ठीक है?
That is the filing number I have indicated.
Filing number.
So I made my representation for extra judicial.
Should we tag it right now, or should we just list it?
Because it is not on board, so it will be listed, and then on that, today 21 can be tagged, because today that is not on board. But it can always be done, because arising out of same improved judgment is the case, involving same issue.
सारे को लिस्ट करा
जी जी,
along with this batch, उसी दिन एक साथ सब में ऑर्डर
I go down.
मंडे को जाए ट्यूसडे ठीक है, पोस्ट ऑन ट्यूसडे इन द
Grateful, I will be there.
वेडनेसडे को
ठीक, I will,
इन द सप्लीमेंट्री कॉर्सेस।
I will do that. Because it
कितने
will be
बजे
taken
करेंगे?
at 4 बजे, तो आप take up.
नहीं, इसको थोड़ा
तो supplementary में रहेगा तो 10:30.
टू बी टेकन अप एट 10:30, आप लोग आ जाइए।
हम आ जाएंगे 10:30 से,
हाँ
10:30.
10:30 बजे।
Yes, I will. Grateful.
तो इसमें हर एक में थोड़ा ऑर्डर ध्यान से करना। हाँ,
One
बोलिए।
matter of serial number 14. I have
14?
Yes, sir. I have given NOC of respondent number 4.
रिस्पॉन्ड ये 14 में क्या है वो?
डेली में
Date. ML of 1/28/2017. Some NOC with respondent number 4.
तो अभी से क्यों बोलना है?
My name में
दूसरा इसका they have already entered it.
they have not filed वकालतनामा sir.
They have already entered it. वकालतनामा आ रहा है सबका नाम।
For respondent number 4 they have not.
कोई बात नहीं, अगली बार आ जाइएगा। और भी है कुछ प्रश्न? और इसमें मेन में
ऑर्डर की किसी को एक कैसे बोलना
आता है इसको कॉल करना।
From date list for order BTP item 2, first appeal 153 of 2024.
तो मिस्टर प्रशांत मतलब कहाँ चले गए? उस दिन वेडनेसडे को